On behalf of the Chuckanut Health Foundation and the Whatcom Community Foundation, thank you for attending today's event. We know your time is valuable, but I believe you will find this to be time really well spent. Public dollars are vital for thriving, healthy communities, and the proper use of those funds matters to all of us, whether we are responsible for getting dollars in the door or receiving and putting them out to work. Our goal for today is to bring the public and private sectors together to learn more about Washington's gift of public funds doctrine, so we have a better collective understanding of how to interpret and apply it for the benefit of our communities. We are fortunate to have with us today Noah Purcell, the Washington State Solicitor General, who will share his knowledge of the gifts of public funds doctrine. Noah is a Harvard Law graduate and clerked for Associate Justice of the Supreme Court, David Souter. He served in the U.S. Department of Homeland Security and was subsequently an associate at Perkins Coie in Seattle, and he was appointed Solicitor General in 2013. Before we go on, a quick housekeeping item. There are pens and paper at your table for the question and answer segment that will follow Noah's presentation, and we will have runners come by to collect your questions. And we are grateful to the Whatcom County Bar Association for partnering with us today. The Bar Association meeting will begin immediately following the Q&A. So at the end of the Q&A, we ask that you please take your conversations outside so they can promptly begin their business meeting. And thank you for your understanding and cooperation with that. Now, please join me in welcoming Noah Purcell.
Thanks a lot. Thank you so much. Hello, everyone. Thank you so much for having me here today. Thank you to the Bar Association and to the Health Foundation for putting this together. I can tell this is my kind of crowd because we have all these people here to talk about this nerdy, deep in the weeds constitutional doctrine. And so I can already feel like I'm among my people. So thank you for having me. And I'm looking forward to talking with all of you today. I'm hoping that this will be as conversational as it can be, talking about constitutional law doctrine and in a PowerPoint presentation. So, feel free to stop me as I go along with questions. I'll also leave a fair bit of time for questions at the end. So we're here to talk about the gift of public funds doctrine. Do you mind going on to the next slide? Thank you. So some people may be wondering, why are you here today when there's a variety of important things that are going on in the world that you may have heard about that I also have to work on in my day job. But I've been in this job for 12 years now, and in my role, I get all kinds of legal questions that come to me from state agencies, from elected officials, attorney general opinions, and this doctrine comes up all the time, and it is definitely the one of all the doctrines I deal with day to day, the one that most often people are confused about. And I'm not saying that to malign anyone. Very smart lawyers get very confused about it. There's a ton of lore about it. There's very few cases about it. And because of that misunderstanding, it frequently leads to, I cannot tell you how many times someone in our office has told me we can't do this or that thing because of the gift of public funds doctrine. And then I look at it and I say, no, actually we can. We just need to, do X, Y, and Z first. And that has happened. That happened so many times that eventually I decided I need to do something about this. It keeps happening. And so that's part of why a colleague and I wrote the law review article that was shared out to you in advance of today, and why I've done some CLEs within our office about this topic to make sure that the AG's office is giving consistent advice about this topic. And so that's why I want to talk about it. And the related reason is that, some constitutional doctrines maybe don't matter that much. This one comes up all the time, and it's frequently invoked in ways that stop discussion of ideas before they really can even get started. And I think that is almost always should not happen, because the gift of public funds doctrine, just to kind of cut to the chase, should not be a barrier to virtually any government program if it's done properly. So that's kind of the upshot of what I plan to say today. And so because of that, I think it's very important that people misunderstand it so often. So if you don't mind going on to the next slide. So before I get into all the reasons why it shouldn't be a barrier, I do want to emphasize a couple of important points. So first of all, as any of you who deal with state contracting or grant making or local for that matter know, this is not the only law that comes into play, right? There's a ton of other laws. There's a ton of restrictions depending on the source of money, how you can use it, where it's coming from, and even more so if you're also getting federal money. So I don't want to suggest that if something is not a gift of public funds problem, there's no legal issues with doing it, right? There might be any number of other challenges that you need to deal with. But oftentimes, as I said, the gift of public funds doctrine gets brought up very early in the process and kind of shuts down conversation. And that is what I think is a mistake, because there's nearly always a way to deal with a gift of funds problem without and still do the program that you want to do. And the last thing I'll say is, just because it's constitutional doesn't mean it's a good idea, right? You all know that. There's a lot of bad ideas out there that there's any number of reasons why state and local government should not fund. But my goal is that people understand that it should mostly be a policy discussion, right? As opposed to kind of a legal, we just can't do that discussion. So there's any number of reasons why something might be a wasteful program, like the money could be better used for something else, but that doesn't mean it's unconstitutional. And so kind of separating out those aspects of public decision-making, I think, is important. So with those caveats, let's go on. Thank you. So some of you, the non-lawyers and even some of the lawyers in the room may be wondering, like, what on earth is this gift of public funds doctrine? Where does it come from? It comes from two sections of our state constitution. And I will tell you, our state constitution is way too long. I'm on record saying that. I don't think it's anything controversial. There's a ton of stuff in there that even experienced lawyers have no idea is in there because it's so long. But this comes from two different sections. And the sections, one deals, Article 8, Section 5 talks about the state. Article 8, Section 7 talks about local governments. They're phrased pretty differently, but our state Supreme Court has been clear for a long time that they're interpreted identically. So for today's purposes, when I say gift of public funds doctrine, I mean these two provisions that, like I said, are separate but are interpreted the same. Sorry, thank you. So where did this come from? It came from a fear at the time that our state was founded that basically the state and local governments would just give stuff away to the railroads. Especially, I think especially the fear was about local governments just giving land, giving benefits to the railroads and other private interests. So that was kind of the origin of the rule. But obviously it's written more broadly than that. And over the years, I won't read all the quotes on the, hopefully, can folks in the back see well enough? Okay, so, but the basic idea to prevent subsidies to private commercial enterprises where there's no public gain was the idea. Thank you. So I'm gonna talk in just a second about the current legal test, which is discussed at great length in the law review article that we sent out. But I think it's fair to say that for about the first 80 to 100 years of the doctrine being in place, our state Supreme Court interpreted it very inconsistently. Very similar seeming programs would sometimes get upheld and sometimes get struck down. And it was very hard to predict how the case was going to come out. A lot of those cases had to do with just like leasing public land to a for-profit entity, for example. A lot of them had to do with ports, and they're just all over the map. And I think it's very hard to explain them, honestly. If you want a history, I encourage you to read the law review article, but if you don't, you don't need to, because the long and short of it is the doctrine was extremely unclear. It didn't make a lot of sense. And then more recently, if you don't mind going on to the next slide, more recently, the state Supreme Court, starting in about the 1980s, developed a fairly clear test. I'm not going to say it always gives a clear answer, but it's much more clear what the test is. And it is a two-pronged test, and it's also a much more flexible test than what the court used for decades. And if you don't mind going on to the next one. So the first question is whether the funds will be expended to carry out a fundamental purpose of the government. And people often skip over this part of the test. In fact, I can't, and I'm, very smart lawyers often skip over this part of the test because for any number of reasons. I think partly because of lore, partly because of, I don't know, just they haven't actually looked at the case law in a while. But if funds will be expended to carry out a fundamental purpose of the government, there is no gift of public funds, and you don't need to go any further. You don't need to worry about like consideration or whether it will only benefit the poor and infirm or any of the other stuff that comes up in gift of public funds analysis. If the program or grant or whatever it may be is to carry out a fundamental purpose of the government, you just stop there and it's fine. You don't necessarily need to stop there because you might be unsure. Maybe you're unsure if it's a fundamental purpose of government and you want to have some backup arguments available to make sure you're being extra cautious. But as a legal matter, there's now a number of cases from our state Supreme Court where they say, no, this was to carry out a fundamental purpose of the government, so we don't need to look at consideration or anything like that. So that's, if you take nothing away from this presentation, please remember that if funds are being spent to carry out a fundamental purpose of government, it's not a gift of public funds. And I'll talk some more about that with some examples in a minute. But first, I'm just going to get to the second part of the test. So if the funds won't be used to carry out a fundamental purpose, and I'll give some examples of that as well, then you get to the question of whether the funds were given with donative intent and what the public received in exchange, right? And this is often the step that people skip to, just talking about, well, what's the consideration? What's the public benefit? What does the government get in exchange? And the case law is very clear, though, that in this test, courts are very deferential to what the public agency says it's getting in exchange and what that consideration might be. And again, I'll talk about that in a little bit more detail. So, for example, the consideration does not have to be money. It can be other sorts of public benefits, like a reduction in traffic or preserving open space or other things like that. These are just a few of, there's more cases cited in the law review article, but so that even when you're not dealing with a fundamental purpose, so you have to look at consideration, it doesn't have to be some sort of monetary benefit. It can be other sorts of public benefits. And you can go on to the next slide, please. Now, separate from that, right, separate from whether there's consideration and separate from whether it's a fundamental public purpose, the case law also makes clear that if a program is to benefit and this is the constitutional language, not how we would phrase it today, probably, if it's to benefit the poor and infirm, then it's also not a gift of public funds problem. And although it says poor and infirm, the case law is very clear that it can be either one. It doesn't have to be, someone does not have to be poor and infirm to get the benefit. And so, for example, as we mentioned in the law review article, nearly any sort of public health program that you might operate would be to benefit the infirm. And you wouldn't need to go any further to ask about like consideration or if all the beneficiaries are low income or that sort of thing. Now, many public health programs would also probably qualify as fundamental purposes of government, so you might not even need to get to this point, but I guess it's just an example of another way that something that a government agency might do would not be a gift of public funds problem. And again, here, courts give very broad deference to local government definitions of kind of who qualifies as poor and infirm. There's not a ton of cases about this, so I'm sure there's some limit that courts would apply if you said that, millionaires qualify as poor, that would probably not fly. But it is, but the courts have been very clear that it is a deferential standard and that they'll give a lot of leeway to government findings about who should qualify. Yeah, if you don't mind going on to the next one. So now I'm going to talk in a little bit more detail about each of those parts of the test, because there's actually a lot of things that our state Supreme Court has recognized as fundamental purposes of government. Now, for the lawyers in the room, I want to be clear, there's not a case about every single one of these analyzing and saying it's okay, but there are a couple of cases where the state Supreme Court said, here are some examples of things that are fundamental purposes of government, and they list all of these things. So the cases, well, anyway, I'll get into some. If you want to know all the cases that have specifically gone there, you can look at the law review article. But these are some examples that they gave in state Supreme Court opinions. And again, I won't read through all of them, and some of them might seem more obvious than others. But it's a pretty wide range of things, and a lot of them are things that state government has done for a long time, and then some of them are things that governments have only probably done more recently, like providing daycare services or fare-free bus zones or things like that. So it's a pretty long list. And, someone asked me in a prior presentation, where does this list come from? How do you decide if something is a fundamental purpose of government? Unfortunately, the state Supreme Court has never really explained that. They've never really explained kind of how something gets in that category. Just looking at the cases and the examples, I think it's a combination of, if it's a thing that the government has been doing for a long time, that would probably make it more likely that it's a fundamental purpose of government. If it's something that is required by statute or is mentioned in the state constitution, that would probably make it more likely to be a fundamental purpose of government. If something is kind of, there's an obvious failure of the private market to provide some service or something like that, and the only way it will be provided is through government provision, that would make it more likely to be a fundamental purpose of government. But I would say the state Supreme Court has talked about this idea pretty expansively. And so, it's, I think, fair to say it's a pretty broad list of things that fall into the fundamental purposes category. I hear some feedback every once in a while. I'm not sure if this, can people hear me if I don't use this microphone? No? Okay, well, I'll keep using it just to make sure folks in the back can hear. So now, what's not a fundamental purpose of government? So there's only a couple of cases about this as well, but the state Supreme Court has said that building a professional baseball stadium, not a fundamental purpose of government. That was, for folks who remember, there was, I think it was the late 90s when there were all those votes about the Mariners Stadium and the Seahawks Stadium. And then also they have said in a case out of Spokane, I believe, building private parking garages is not a fundamental purpose of government. But notably, both of those cases, the court still found no gift of public funds because it found adequate consideration. So I'll talk about that in a minute. But these are two examples where the court said that's not a fundamental purpose of government. Oh, for the microphone? Okay. Well, I can try just yelling for a minute. Can folks hear me if I, no, yeah, no? Okay. Okay, well, we'll power through for now. I'll try to keep it at the right distance. So if you don't mind going on to the next slide. So now, example. So, I mean, I think this is sort of an obvious example, but there is a case about it very specifically. So I'll talk about it briefly. So the court has said that, oh, do you want to, okay. Okay. Is that better? Okay, excellent. And now I can stop making quite so many awkward hand gestures also, hopefully. So disposal of solid waste is a fundamental purpose of government. That's kind of long accepted, unsurprising, right? Garbage collection, recycling collection, fundamental purpose of government. So what does that mean, though? So that means that basically, again, there's any number of other laws that regulate how the state and local governments can do that. But the gift of public funds doctrine is not a meaningful restriction on how the state and local governments go about providing that service, right? They can hire a private company to do it. They can do it themselves. They could hire a nonprofit. Any number of ways they could provide that service. And I use that example to start off because I think it helps you think about, well, so what does that mean for other stuff that might not be as obviously immediately a fundamental purpose of government, but that our state Supreme Court has said are fundamental purposes of government. So if you don't mind going on to the next slide. So right, those same principles apply in areas like higher education, daycare services, other things that our state Supreme Court has said are fundamental purposes of government. That once it's a fundamental purpose of government, state and local governments have very broad discretion about how they go about trying to provide that service. Again, within the gift of public funds doctrine, not speaking to whatever other laws might regulate those specific provisions. And if you think about it, I mean, like higher education, for example, higher education, when someone goes to the University of Washington or Western Washington University, there's any number of students who might get financial aid because they're low income. But even for a very wealthy student from a very wealthy family, they're getting subsidized going there, right? The university is not charging the full cost of providing that education to students, even if the students are very wealthy. And that is not a constitutional problem because higher education is a fundamental purpose of government. Now, that doesn't mean that we have to do that, right? We could charge vastly higher tuition and make everyone pay the full cost. but we don't have to do that because it's not a gift of public, because it's a fundamental purpose of government. Let me stop there for a second and just see if people have any questions about that, because I'm trying to start with kind of some examples that I know this is kind of different from how a lot of people maybe have thought about these issues over the years, and may spark some questions and thoughts. But like the Equal Protection Clause, you couldn't make decisions about who gets the benefit based on race or gender or other protected characteristics without violating some laws. But the gift of public funds doctrine would not say it's only a fundamental purpose if you give it to everyone. So no, I don't think that is a key factor. Yes.
Well, let me just jump off that question. Does it need to be directed for residents or citizens walking the state? Sort of looking at the other example, we subsidize e-state tuition. We don't subsidize that state. I think I would say you pay more than cost. So is there any analysis there as far as
That's a very interesting question that I can't think of it. So the question was, does it have to be directed at Washington residents? I'm not aware of any case about that. And I think the answer might vary, to be honest. Like police and fire services, if you have an emergency, everyone would agree that that's a fundamental purpose of government. We don't ask, like, are you from here before we would respond to your 911 call, right? So I don't think it necessarily has to be, but it might depend on why it's a fundamental purpose of government, right? Like that, we provide that service to protect public safety and to respond to emergencies. Higher education, arguably, the fundamental purpose, again, because the court has not said exactly what makes something a fundamental purpose, it's a little hard to know. Arguably, the fundamental purpose would be to provide education to people in Washington. But you could also describe it more broadly. I mean, we certainly get a huge benefit from people who come here for school and stay here afterwards. So I honestly don't know. And that might, it probably depends on the benefit and the type of benefit to some extent, at least. And you'll hear me say in answer to questions today a fair number of times, right? I don't know, but still, I think that the key point is that a lot of stuff falls into the fundamental purpose of government category that people don't necessarily think of, and that your legal questions should be kind of like around the edges, like what you're talking about, and not, can we do this at all? And so, yeah, so I think there will be a fair number of I don't know answers, but I think it's more about like, let's talk about the gray areas around the edges and not just the big picture. Okay, why don't we go on to the next slide, and then of course, there'll be more time at the end for questions. So I just, this is just kind of getting at the same point. So that there's a bunch of different ways we provide fundamental services of government, right? Public schools, obviously, fundamental purpose of government is government service provided directly by the government, right? We also, though, provide services in a wide range of ways, right? Like contracts with solid waste disposal companies are providing a fundamental service of government. That is a contract with a private entity. Some local governments do it differently, but for the most part, those are contracts with private companies. And then other services we provide, right, often through contracts or grants to nonprofits, or through a mix like childcare or housing. And some things we provide in a mix of ways, right? Some things the government provides some housing directly, for example, through government agencies like housing authorities, and then also provides it in other ways like through grants or private contracts. That all, again, bunch of other laws that come into play, but all of that is fine under the gift of public funds doctrine, as long as it's a fundamental purpose of government. Next slide, please. Now, okay, so now we'll talk about kind of the parking garage and the stadium example, and the many other examples that fall into the non-fundamental purposes of government. And I think this is also helpful to talk about because there might be a range of areas where you're not certain if something is a fundamental purpose of government, and you want to cover your bases, right? Lawyers are cautious. We want to make sure we don't get in trouble. And so you want to not only, we might think something's a fundamental purpose of government, but we might still want to say, even if it's not, here's what we're going to do to make sure we're not doing anything wrong. And so, right, as I said, in those two cases, the court still found that there was no gift of public funds problem. And do you mind going on to the next slide? Oh, sorry. Let's go back to that one. Sorry about that. So, and what I guess what I would emphasize is when you are thinking about a program where you're not sure if it's a fundamental purpose or not, or even if you're sure that it is, but you just want to be extra safe, there's a range of ways for government agencies to make sure that you're being explicit about what
the government thinks it's getting in exchange, right? What are we getting for this benefit that we're providing, this money that we're providing? So in the example of the private parking garage case, it had to do essentially with kind of economic development in downtown Spokane. And what I would say is it never would hurt to have in a whatever, you know, if it's a resolution from a city council or county council, or it's a contract provision, some explanation. Number one, if you think it is a fundamental purpose of government, just go ahead and say that, you know, this grant is to provide childcare, which is a fundamental purpose of government. You know, I'm not saying that has to be in there, but it wouldn't hurt. And then number two, say, and also, you know, by providing this grant funding, our city is getting the benefit of, you know, increased availability of childcare services and working parents being more able to work, and, you know, whatever other kind of benefits you think flow from the decision. And presumably you think there's some benefits, or else you wouldn't be giving the public money in the first place, right? Whatever those benefits are, put them in the contract or the resolution so that there's a record of kind of what the local government thinks it's getting in exchange for that funding. And, you know, as I said earlier, there are a number of cases that recognize that it doesn't have to be monetary. It can be things like, because we're doing this, we are going to preserve this parkland, or because we're doing this, traffic will be reduced in this area, or what have you. It can be non-monetary benefits. Let's go on to the next one, please. Another important thing that I added this kind of later because I realized that there's a fair number, if I understand right, there's a fair number of local government folks in the room, and often one of the areas that I've seen a lot of confusion about is one government agency thinks it can't do something for another government agency because it would be a gift of public funds problem. Like we have this land that's vacant. We're not using it for anything. We don't have any plan to use it for anything, but we can't just give it to the housing authority because that would be a gift of funds problem. And setting aside everything else I talked about, fundamental purpose, consideration, all that stuff, the courts have made clear that no, if you're basically transfers between public agencies are not gifts of public funds. So, you know, if you have one government agency has some land or property or what have you that they're not going to use or not using, you know, all the other doctrines I talked about would come into play if they were going to give it to a nonprofit or a private company. Like, what's it being done for? Is it for a fundamental purpose? You know, is it being done to build affordable housing or childcare or what have you? You'd have to look at all that stuff. But if it's just a transfer between government agencies, it's not a gift of funds problem. Now, it might be, I mean, to be clear, again, there might be other legal restrictions, like how was the land acquired? Is this a misuse of like utility ratepayer money as opposed to taxpayer money, stuff like that. But it's not a gift of funds issue. And again, there's all these cases are cited in the law review article that we sent around. So I'm kind of coming to the end of the presentation here, and then we'll have a lot more time for questions. But I tried to include here just kind of a list of things that folks could use to think about how you analyze a gift of funds question, and all the many ways in which you don't have to, you know, all the many ways in which you can kind of jump off of the concern and move on. And so obviously each of these covers up a significant amount of complexity, right? How do you decide if it's a fundamental purpose? Details about who qualifies as for or infirm, and all those things. But it's because of all these off ramps that I said at the beginning, and I'll say it again. My view is that there's almost nothing that a government agency would want to do that it could not do if thoughtfully implemented under the gift of public funds doctrine. And I know that when I say that to some, you know, longtime colleagues in the AG's office, they're temporarily like veins start throbbing in their head and stuff. But ultimately, when I've talked this through with people who have very strong initial counter opinions, but after we've been through it at some length, ultimately they pretty much agree with me. It's just a question of how the problems that we have seen over the years are when government entities fail to document, fail to explain what the purpose is, fail to document what they're getting in exchange, that sort of thing. You know, every once in a while, yes, there's just like flat out, that was an attempt basically at corruption, something like that, but that's extremely rare, right? It's not, and there's other laws, as we talk about in the law review article, there's a lot of other laws that deal with that. And, there's a lot, there's the ethics and public service laws and so on. There's any number of laws that restrict corruption. And the gift of public funds doctrine is really only a limited, that was the original goal, and it was meant to get a kind of big picture corruption of like a public vote to do something that the government should do. But for the most part, issues about corruption are dealt with by other laws, and the gift of public funds doctrine doesn't really do much on that front. And I'll give you an example just to highlight that point. If you imagine a road contract, right? Everyone agrees that building roads, providing transportation would be a fundamental purpose of government. So say you have a county employee and they've got 2 bids to build a road, and the bids are exactly the same, right? Building the road is definitely a fundamental purpose of government. There's no question about that. But they choose one bid because it's their cousin, or they choose one bid because the person pays them some money. That's not a gift of public funds violation, because it's a fundamental, they've broken the law and they should be punished, but it's not a gift of funds violation because the purpose of the program is to carry out a fundamental purpose of government. It's to build a road, right? It's totally corrupt, it's illegal, they should be punished, but other laws deal with that sort of corruption. And so I guess I just want to highlight that I'm not saying like, I don't care how public agencies spend their money, it should be willy-nilly, not at all. I think it's very important that we are good stewards of taxpayer dollars and that we make good decisions about how to use the limited resources that we have available to prioritize the right things. But again, the reason I'm here today, the reason I'm so passionate about this seemingly boring topic is that it frequently gets invoked to stop, the discussion stops before you get to those sort of policy discussions about what's the best way to do this, what's the best use of our funds, how can we best pursue this important problem, whether it be homelessness or childcare or what have you. It just stops with, no, we can't do that. And my main point here today is to say, you probably can do that. You just need to be careful and thoughtful about how you go about doing it. And I'll close with, do you mind going to the last slide? Just to kind of drive that point home. We looked very, very hard, me and my team in the office. We could not find a case basically in the last 50 years in which a Washington appellate court had found something to be a gift of public funds problem. Now, in part, of course, that's because state and local governments are doing their job well to avoid it. But I just wanted to highlight that under the doctrine as it's developed over the years, it's not just my opinion. I don't think that it is very forgiving. It is possible to comply with very broadly. And there's virtually there's no recent examples of anything being found by a court to be a gift of public funds. So that, I think, is my conclusion. That is the last slide that I have. I know there's a lot of other questions in the room and topics to discuss. I think Steve got some questions submitted in advance. Do you want to start with the questions that were submitted in advance, and then we'll open it up to more questions in the room? All right. Excellent.
Okay, thank you, Noah. For our in-person attendees, please do write any questions on the blue paper on your table and raise your hand so a staff member can come by and collect them. And for those of you who are online, we are monitoring the chat, so please type in your questions and we will get to those if we can as well. We will start with a few questions that have been submitted through the registration process. The first of which is, we currently use public funds that can be used for gas, groceries, etc., and expect receipts for reimbursement. Local nonprofits would like to be able to purchase gift cards, which we cannot allow due to the opportunity for ineligible purchases and therefore gifting of public funds. What is happening in other places, and what is the best practice to address this?
So that one is complicated because there's a lot of moving parts there, right? If a program is to benefit the poor and infirm, then it's not a gift of public funds. So, right, if you are giving out grocery gift cards to low-income individuals, I mean, I think it would not be a gift of public funds to do that. I mean, and that would be true even if it's not to further a fundamental purpose of government. There is no gift of public funds problem if a program is to benefit the poor and infirm. Now, so let me give an extreme example. This would probably be a terrible policy idea, but I think you could, if you wanted to give gift cards to low-income individuals to golf at the local golf range, that's not a gift of public funds problem. It's probably really stupid, and not the best use of money, but it's not a gift of funds problem because the program is to benefit the poor and infirm. Now, I think this question kind of mixes in another idea, though, that I assume that the gift cards, I don't know, exactly where this question came from or exactly the underlying program. I assume the gift cards are more like grocery store gift cards or what have you, or Target or something like that. Again, if it's limited to the poor and infirm, I don't think it's a gift of public funds problem. But I could understand why, a local government, a grant making agency, a nonprofit might say, we don't want, we're too, because of the range of things that's going to be spent on, this isn't the best way to achieve our goal of giving people food assistance or whatever other kind of assistance it is. And I could also imagine that part of what might be going on here is if a local government is giving money to a nonprofit and then the nonprofit is the one giving out the gift cards using kind of their own criteria, the local government might be very nervous that we don't really know exactly who's going to get them, exactly if they're all, would qualify as low income, and then what they're going to be used for. So it's a little hard to answer that one because there's so many moving parts to it, but I'm just trying to walk through the, yes, go ahead.
You're trying to get out of the other.
No, I'm happy to, I'm assuming it's related to that
Yeah.
question, but yeah, go ahead.
Has there been an analysis of what it means to benefit the poor and infirm? Because
Not,
just giving them anything considered a benefit to them.
yeah, sorry, the question was, has there been an analysis of what it means to benefit the poor and infirm? I can't recall a Supreme Court case that addresses that in any detail. As I said, though, the court has been very explicit that local governments get a lot of deference, the state and local governments get a lot of deference about both who qualifies and what it means to kind of help them. So I would say, I would want to be cautious, but I think there's, and I would want to document why, whatever the program is taking the view that it benefits the poor and infirm. But I think there is a lot of leeway for local governments in interpreting that term, that phrase. You want to do another one from the?
What is the threshold for poor and infirm, below which more flexibility of support is allowed? This is generally assumed to be 80% AMI, when some recent legislation allows this up to 115 or 120% AMI for certain uses. Could we please discuss how these limits relate to the gifting of public funds and what is happening in other places and what may be on the horizon?
Okay, so this is also a complicated one, and it's, I think the first thing I would say is it's an area where local governments and the state, again, I think get a lot of deference. And honestly, the answer kind of has to vary a little bit, right? What makes someone low income in rural Franklin County is different from what makes someone low income in Seattle, right? For example, just because the cost of living is so much different. So I think we can say, although there's no case exactly about this, I think we can say with some confidence, it's not just like anyone who makes below $24,000 a year qualifies and anyone who makes above doesn't qualify, right? It can't be a monetary, it can't just be some income level. It has to be somehow based on relative expenditures and so on. Beyond that, it's really hard to say, I think. And I was just chatting with someone earlier about how, even people who make a very decent salary, for example, struggle with childcare costs, right? Because it's just so expensive. That doesn't mean that they're poor, right? I don't think you could plausibly say that someone who lives in Seattle and makes $150,000 a year qualifies as poor, even if they can't afford childcare for their 3 children. So I think that long and short of it is, there's not a bright line answer that I can give you. I don't think, as far as I know, there's not some case saying that 80% is fine and 90% would not be fine, or or what have you. I think obviously the lower the threshold, the lower the income threshold, the more cautious you're being, the safer you're being. But I do think that there's, again, the courts have been very deferential, and I think that I could imagine a local government saying, for example, for housing purposes, we're going to use 80% of the local median income because that in some way gets at what people can afford to spend in this area on housing. But for trying to think of a good example, but for childcare, because it is so expensive, we're going to use a slightly higher threshold because it would just because what poor means in that context maybe is different because of the relative expense, the expense compared to their income. Maybe housing was probably a bad example to give at the beginning because housing is such a huge part of people's income. But I guess the long and short of it is I'm saying this is an example of where I'm saying I don't know. I'm saying there's some gray area, but I think there's a fair amount of room for local governments to say this expense is so large that even people right up to our local median income would qualify as poor or should qualify as poor under our definition. And in part, it could also be because if they don't, having to spend that much on childcare or housing would effectively make them poor, right? I mean, it would impoverish them. So I think there's, again, I would just say there's not a case about this. I'm not encouraging you to push the limits of this. Most things, frankly, that the government does to benefit poor and infirm also, I think, qualify as fundamental purposes of government. So I would start with that rationale before testing the limits of whether someone making, for example, like 125% of the median income could qualify as poor. But I do think there's some flexibility and not a bright line rule. So sorry, I can't give you a clear answer.
What is the difference between a gift of public funds and a lending of the state's credit?
So in terms of the legal test of what makes it problematic, it's basically the same analysis, but they kind of fall into different, so these cases arise in different ways, and lending of the state's credit can come up in things like, well, literal lending, like literal bond programs. So that language tends to get emphasized in cases where, for example, the government is issuing bonds for a purpose that someone thinks is not, thinks amounts to a gift. Whereas the gift language tends to come up more in kind of straight up grant making scenarios. But in terms of the legal analysis of whether it's problematic, it's essentially identical. To be honest, we don't talk about it in a law review article, and there is a separate a professor named Hugh Spitzer at UW has written a law review article about kind of that distinction. And if you really want to get deep in the weeds of lending of credit versus gifts, I commend that article to you. But the ultimate point is that in terms of whether it's legally problematic, the test is the same, and it's what I'm talking about today.
Next question is, how do we address misunderstandings of the gift of public funds problem? Quote, before they shut down program pilots pragmatically. How do we explain these broad definitions before they go to court?
Well, again, I guess I would emphasize that whatever your authorizing document is, whether it's like a city council resolution or a county council resolution or budget language, or it's a contract between the government and the nonprofit or the government and a private provider, that you, in whatever that document is, you give as much explanation as you can. If you think it's a fundamental purpose, say that, and maybe, if it's not one of the areas that's kind of already been recognized as a fundamental public purpose, say even more about it. So for example, in the law review article, we mentioned combating climate change as an example, right? There's no case that says combating climate change is a fundamental purpose of government. At the same time, by all the criteria that I talked about earlier in terms of like, this is a problem that really only government can have the scope to address, and it's a huge existential threat, and flood control, for example, has been recognized as a fundamental purpose of government. So probably, very probably, our state Supreme Court would say that combating climate change is a fundamental purpose of government. But if I were funding a program to combat climate change, I would want to explain a little bit why in the resolution we think that, like explain what the impacts are locally, explain why it's such a problem, that sort of thing. For something that is so that's one point. And then again, if you're not sure it's a fundamental purpose, also go on to explain what the government or the public is getting in exchange, right? Explain, again, to use the climate change example, presumably there are benefits in cleaner air in other areas that you would want to talk about that the public is getting in exchange for these expenditures. And in some areas that will be really profoundly obvious, and in other areas it might be harder. But I think it would be important to detail what those public benefits are in the, again, in the either the authorizing resolution or the contract. I talked to our Assistant Attorney General who advises the auditor's office before coming up here to talk to him about some of the things he's seen over the years. And what he said, something very similar, that essentially 99% of the time that they find a problem with some local program, it could have been addressed in advance by detailing better what the purpose of the program was, what the consideration was, and those sorts of things that I'm talking about here today. So anyways, all that to say, just back up the benefits that you think are coming from this program. And actually, sorry, maybe there was a question online that I just wanted to, because I thought about it a fair amount before coming. So there was a question about, for example, could you subsidize the wages of private childcare workers? And I think that question gets at a couple of these points. So I thought I would talk about that a little bit, because I think the short answer is I think yes, because providing childcare is a fundamental purpose of government. And even if you weren't sure about that, what you would want to do if a local government were going to somehow subsidize the wages of childcare workers, you would want to make some findings about, here is what we get from doing that, right? We get the benefit of the more stable childcare workforce. We get the benefit of more spots available to local kids so that parents can work. We get the benefit of better staff working in these institutions, and so on. And so anyway, the long and short of it is, I thought that was an interesting question, because I think the answer is yes, and I think the answer is yes under several different parts of the analysis, but you would want to back up each of those and hopefully that's a helpful example to say, like, here, you would say it's a fundamental purpose to provide childcare, and then you would also say, here's what we get, here's the reason we're doing this, and here's what we see the public getting in exchange for us providing the subsidy. And that should be enough to cover your bases, even if for some reason, something very unexpected happened and the court said it wasn't a fundamental purpose of government. Now you have documented the consideration that the public is getting in exchange for that program. So I just wanted to use that example.
Okay, if a program is deemed non-implementable and 3 words are added, poor and infirm, would you say that is enough to deem it illegal?
Okay, so I assume the question is, it's deemed non-implementable because it's a gift of public funds, and then you add the poor and infirm idea. I mean, that would be a roundabout way to get to that conclusion, because I assume, I mean, there's certain things that you probably could not do unless they were only directed at the poor and infirm, but that would be few and far between, and probably not the sort of program that most government agencies would want to do, because again, most programs, right, that are designed to benefit the poor and infirm are things that fall into the fundamental purpose of government category. So it would be a pretty rare thing that you would just like kind of tack that on at the end and say, we couldn't do this otherwise, but we can do it because it's directed at the poor and infirm. Now that said, if you're right, the cautious lawyer in me would say, if you're designing a program and you have limited funds to begin with, so you have to target it in some way, then in addition to it being a fundamental public purpose, and in addition to documenting the consideration, say that it's limited to people making up to X percentage of the median income. And then you have a third reason to say this is not a gift of funds problem. I'm not saying you necessarily need to add that to every program, but if you're going to have to limit it anyway, right? If there's not going to be limitless funds to provide the service to everyone, then add that as an added layer of protection for why the thing you want to do is fine. And that's an added layer of legal protection. But I do want to just convey, there's a lot of things you can do and provide beyond serving the poor and infirm under the fundamental purposes of government rule. So short answer, I don't think you just tack it on at the end, but it is a helpful additional defense, and it does allow some things that wouldn't be allowed otherwise.
Interesting question for the climate that we're in right now. Has Washington State developed tests or modes of analysis governing the use of public funds for public communications or advertising that are arguably partisan or forms of political speech?
I can just quickly, that's my question, I just kind of clarify the federal example, not the political, but, you know, for example, and again, it's a federal example, but the White House and the Trump administration's recent, a $200 million television ad, it's still in the version of their deportation campaign, and I saw it recently, and it really is kind of indistinguishable from the campaign fee, and it lambasted the prior administration. And so I'm wondering, I know, most of my practice is in California, and California has its own kind of Byzantine set of rules about how to determine whether or not somebody treads infamously towards, advocacy or partisan political speech. But I'm just wondering if Washington has any set of rules or rough guidelines about where you draw that line when something that is, a fundamental purpose of government, communicating to the public, starts to sound a lot like advocating for particular administrations, particular incumbents' views and policies.
Okay, so I think the primary restriction on use of public funds for any sort of campaign purposes would be in the Fair Campaign Practices Act that limits, and in the Ethics and Public Service Act and other provisions that limit the use of state resources for any sort of partisan campaign purposes. So that because as kind of implicit in your question, right, is the point that certainly some advertisements and messaging the government would put out would serve a fundamental government purpose, right? I mean, we need to inform the public about how to get these vaccinations or how to sign up for the childcare program or what have you. So clearly, a lot of things government can advertise, can put messaging out about. The problem comes in when it seems to cross over into, well, this isn't to inform the public, this is to raise the profile of this elected official or to help support this initiative that's on the ballot or what have you. But the almost all of the tests about that stuff, and there's a lot of cases about it, would come from the case law about campaign finance laws and use of state resources for campaigning. So I think the gift of public funds doctrine would kind of be it wouldn't be the main issue there at all. It'd be more because you definitely, like I said, you definitely can use public funds to get messages out. The question would be, what are those messages and are they not? If they're too political, then it's a problem under those other laws. Before, probably it's a problem under the gift of public funds law or doctrine.
Okay, with that, we are going to have to close up this session. If we were not able to get to your question, Noah has graciously agreed to answer them at a later time. And we will be sending his responses to all attendees along with a link to the presentation recording. So first of all, please join me in thanking Noah Purcell for making very helpful, and we appreciate it.
Well, thank you again, everyone, for having me. It was great to be here, and I will stay for the bar lunch. And I'm happy to answer questions and chat with folks.